Gorsuch.
Just if states wanted to do this not by tort law, but wanted to do it by regulatory law, they could do that, I assume, as well, correct?
But it would be limited. Its ability to do that would be severely limited.
Tell me what the limits are.
The limits are the non-discrimination principle that we discussed, and also we certainly do not argue that there is
a general state regulation of workplace safety. That would be non-discriminatory, right?
That would be non-discriminatory, but again, that might conflict with the provision.
Employee rights. That would be non-discriminatory, right?
It's not clear if that would include a soldier overseas, and also
It's a contractor.
to a contractor.
A military contractor overseas. The state wants to apply its employee rules, its workplace safety rules on a non-discriminatory basis, yes or no?
No, because the DBA already precludes things like that.
What kinds of regulatory, but you said some could be applied, right?
If it was like a safety regulation, like here, that could certainly be it.
What do you say to the retired military brief that says that this is going to, your rule would lead to finger pointing, which I think this suit would lead to finger pointing by the defendant against the military and back and forth on that? You know, how does someone who used to be in the Taliban end up running a 5K or whatever it was at the starting line? That's going to be a lot of finger pointing on that. And the retired military officers say in military theaters, legal uncertainty and finger pointing are an invitation to ruin. And I'm just curious your response to that.
So this is a situation where the military already found that it was not responsible, it was Fluor's responsibility.
Well, the military found that, right?
Oh, certainly. I mean, so
Yeah.
there might be finger pointing, but
Certainly Fluor's not going to agree with that, right?
at the end of the day, if there's just a possibility of things that might unfold during discovery or evidentiary issues.
Would you imagine in state court, like generals, military officers coming in for testimony about what our rules were for the people who worked in the vehicle yard, what our rules were for who could run in the 5K, why we had former Taliban working on a U.S. base at Bagram? You know, that'd be an interesting discussion, I'm sure. Do you envision that kind of testimony happening in the state court?
No, not at all, because here the Fourth Circuit already agreed with us that the litigation here would not lead to assigning fault to the military. We can assume military made decisions that it made, and we can judge Fluor's actions under those military decisions as a given. We can take that as a given.
Have any federal courts gone your way on this general issue so far?
So the Padilla court has agreed with us, and that's why there was a circuit split in this case.
Okay, thank you.
Justice Barrett?